Good morning, good afternoon, good evening. Depending on what time you are listening, my name is Justin Grimske. I am a senior partner at Seacrest Wardle. I'm a proud member of the firm's Premises Liability Practice Group. So during this installment, which is the final installment of this year's Premises Liability webinar series, I'm going to be talking about the difference between premises liability and ordinary negligent lawsuits. So what are they? Well, generally speaking, when a plaintiff drafts a complaint for damages arising out of alleged negligent conduct occurring on a defendant's property, an important consideration they will take into account is whether to plead a cause of action for premises liability, general negligence, or both. Well, why does this even matter? The distinction is often claim dispositive, and that's because defense-friendly open and obvious doctrine can apply to bar many premises liability claims. However, this defense has no application to general negligence claims whatsoever. And what is the open and obvious doctrine, you ask? Well, luckily, if you're not familiar with this defense or just need a refresher, on September 8th of 2024, my partner Mark Masters presented a webinar on this defense, and I encourage you to take a listen. It's important considering in July of 2023, our Supreme Court in the Candel El Sayed matter revised the premises liability framework. Now, that said, the Candel El Sayed opinion explicitly stated that it did not abolish the open and obvious doctrine. Instead, it declared the open and obvious nature of a condition as being relevant to the element of breach rather than to the element of duty. And specifically, as part of that breach inquiry, the fact finder may consider, among other things, whether the condition was open and obvious and whether, despite its open and obvious nature, the land possessor, often the defendant, should have anticipated the harm to the invitee, often the plaintiff. But for today, as a reminder, a danger is open and obvious if an average user with ordinary intelligence would have been able to discover the danger upon casual inspection. So that's fine and dandy, but what is a premises liability case? What is an ordinary negligence case? How are they different? How are they the same? Well, the easiest way to decipher the two is as follows. Premises liability cases arise from conditions on the premises, whereas ordinary negligence, often sometimes referred to as general negligence cases, stem from the conduct of the defendant. This may sound simple, but in practice, the distinction is not always as obvious, which is why we often see plaintiffs' attorneys plead both causes of action. Even some experienced lawyers will often attempt to describe and perhaps artfully plead the same injury-producing event in terms more favorable to their legal position, which most of the time would be ordinary or general negligence, just to get around that open and obvious doctrine that we talked about earlier. Irrespective of this, let's do a little bit of an exercise. During this, ask yourself, was the injury caused by the condition on the premises or was it caused by the defendant's conduct? For example, let's say you go shopping at a retail store and you slip and fall in a puddle of clear liquid that was spilled in one of the aisles. To decipher between premises liability and ordinary negligence, ask yourself a series of questions. Was the injury caused by the unsafe condition on the premises? Well, in this particular example, sure, it was caused by the puddle of clear liquid on the ground. Or was the injury caused by the conduct of the store employee in failing to clean up the spill despite having noticed it? Well, perhaps. See, what sounds like a bright-lined legal rule in theory is less clear in application. But, as we'll see later, this example would likely be classified as a premises liability claim as the injury was caused by a condition on the land. Now, as you may start to see other examples, they can get rather confusing. Thus, as mentioned previously, in order to get around the defense-friendly open and obvious doctrine of premises liability law, plaintiffs will normally take two general approaches in their pleadings. First, they'll plead multiple counts. Plaintiffs will plead both a premises liability claim focusing on the alleged dangerous condition on the land And they'll also plead a general negligence claim focusing on the wrongful conduct. And then second, we often see plaintiffs will just allege only the ordinary negligence, emphasizing the alleged wrongful conduct of the defendants rather than focusing on the premises per se. Now, in response to these tactics, the case of Adams versus Adams held that regardless of the pleading made by a plaintiff, it is well settled that the gravamen of an action is determined by reading the complaint as a whole and looking beyond mere procedural labels to determine the exact nature of the claim. That quote is really the standard for deciphering between the two. You must ask, what is the gravamen? Meaning, what is the most serious part of the allegation? What is the essence of the allegation? That is what you must ask yourself. So let's talk about some cases. First, we'll highlight on a few published cases, and then later we'll discuss some unpublished cases, as well as go through a chart that was published by the Michigan Bar Journal that goes through each cause of action with its respective facts. Of note, there is little published case law distinguishing between premises liability cases and ordinary negligence. However, an important starting point is the 2005 Michigan Court of Appeals case of Lair versus Kitchen. So what happened in that case? Well, plaintiff was helping the defendant repair a farm tractor on defendant's property. During the repair, the bucket on the tractor moved as a result of the repair work, pinning the plaintiff between the bucket and the tractor body, ultimately resulting in the death of plaintiff. As a result, a wrongful death complaint was filed, which alleged a single generalized count of negligence without specifying whatsoever the underlying theory of liability. The trial court granted summary judgment in favor of the defendant under the open and obvious doctrine, holding that the claim sounded in premises liability and that defendant had no duty to warn the decedent of this obvious danger. The Court of Appeals, however, reversed, but with separate opinions written by each of the three panel judges opining this is more suitably a general negligence case. So the two main points we take from Lair was, well, this is the first time that the court really acknowledged the difference between premises liability and ordinary negligence cases. And then second, this is the first time that the court acknowledged the open and obvious doctrine does not apply to ordinary negligence cases. So by history, that's where we started. The next published case I want to discuss is Belulis versus Trinity Continuing Care Services. This is a 2012 case. Now in that case, the plaintiff slipped and fell on ice on the patio near the entrance of a building owned by the defendant. The plaintiff asserted both causes of action, premises liability and ordinary negligence. In response, defendant filed a motion for summary disposition, which the trial court dismissed the premises liability claim on the basis of the open and obvious doctrine. Now, the court also refused to dismiss the ordinary negligence claim. The Court of Appeals reversed that decision, and in doing so, held if the plaintiff's injury arose from an allegedly dangerous condition on the land, well, certainly that action sounds in premises liability rather than ordinary negligence. The court further explained that this is even true when the plaintiff alleges that the premises possessor created the condition giving rise to the plaintiff's injury. So we must remember our example at the store that we discussed earlier. That is why it is likely a premises liability claim. Plaintiff's injury in that case resulted from the condition on the property. Now, in Belulis, the Court of Appeals further stated that applying the rule to the facts of the case, the court held, though, plaintiff asserted that Trinity's employees allegedly caused the dangerous condition at the time. This allegation does not transform the claim into one for ordinary negligence. Therefore, plaintiff's negligence claim is really a common law premises liability claim that the open and obvious doctrine disposed of. Now, since Lair versus Kitchen, the Court of Appeals has issued dozens of unpublished opinions dealing with this subject matter, and some provide helpful guidance. Now, spatial limitations in this podcast do not allow for discussion of the body of the unpublished case law, but there is a chart that is authored by the Michigan Bar Journal that depicts these cases very well. And we'll go through a few of those cases. The first case I want to discuss is Berry versus Dearborn Heights Montessori. And in that case, plaintiff fell off a stage that was alleged to have been built improperly. Now, despite this allegation, specifically that of defendant's conduct in building the stage improperly caused the plaintiff's injury, the court dismissed this and instead found that this was a case of premises liability, that plaintiff's injury was caused by a condition, i.e. the stage in that case. And the Berry versus Dearborn Heights Montessori case is similar to the next one I'd like to discuss, and that one being Davis versus Olympia Entertainment Incorporated. In that case, plaintiff sued for both premises liability and ordinary negligence when she fell inside of the Fox Theater in Detroit. Plaintiff alleged that defendant breached its duty to properly usher her to the correct seat, thereby causing her to trip and fall when she attempted to find the correct seat in the dark. In holding that plaintiff's claim was one of premises liability and not ordinary negligence, the court elaborated, plaintiff fell as she attempted to locate her seat in the dark, causing her to miss the stairway's next step. Thus, her injury was allegedly caused by a dangerous condition on the property, namely a dark step, and not the conduct of the defendant, i.e. their failure to properly usher her to her seat. Next, I'd like to discuss the Perkins versus Mid-Michigan case, and this is a case where the court found that it was a case of ordinary negligence because by failing to repair a swing step, despite plaintiff's repeated requests that defendant do so, the court found that defendant had breached its duty to maintain the industrial vehicular equipment with which plaintiff was required to work in a safe, operable condition, thereby finding the defendant's conduct was the gravamen of the complaint, as we discussed earlier, thereby making it an ordinary negligence case. Now, also an unpublished decision, this one in April of 2024. The Court of Appeals went through a very thorough and nice framework in discussing ordinary negligence versus premises liability cases. This is the case of Farrar versus Misch. In that case, a man named Jody Misch, he invited Nicole Kenworthy to his property to, quotation, talk. Now, after spending some time together, Misch ultimately told her to leave the property, and prior to doing so, he noticed that she was standing in water, which he told her, hey, don't walk any further into the woods, there's a nearby swamp. The next morning, Misch had contacted police and reported that Kenworthy was missing. He consented to the police searching the property, and unfortunately the body was found submerged in a swamp on the property itself. And in response, Kenworthy's estate filed a wrongful death action against Misch under theories of both ordinary negligence and premises liability. Misch moved for summary disposition, and the circuit court granted it as to both theories. First, the court granted as to plaintiff's or the decedent's ordinary negligence claim because this was a premises liability case, the court elaborated. And then second, the court even went as far as dismissing that premises liability case because defendant argued that he did not have possession and control of that property. Now, on appeal, the court noted that to allege a viable ordinary negligence claim, the plaintiff must allege negligent conduct distinct from the condition on the land. The court noted that an ordinary negligence claim can be asserted when the allegations relate to the creation of a dangerous condition on the premises caused by defendant's failure to act. However, an ordinary negligence claim is not viable where the claim concerns the creation of a dangerous condition. Rather, in this case, it's undisputed that the decedent drowned in a swamp, and that swamp is a condition on the land. Thus, plaintiff's claim sounds in premises liability and not ordinary negligence. The Court of Appeals found that the trial court did not err in granting summary disposition to the defendant on this claim, even though it did so for a different reason. The Court of Appeals reached a different conclusion, however, on the estate's claim for premises liability, finding a question of fact on the possession and control issue. Thus, that portion of the case was remanded back down to the Muskegon Circuit Court for further proceedings. And as noted earlier, these further proceedings would apply the new framework, the Candil-El Sayed framework, including application of the open and obvious defense or doctrine through the finality of the case. So, in summary, if there is a focus on a defendant's actions in the absence of a premises liability claim, or if a physical act by the defendant directly caused the plaintiff's injury, a viable claim for ordinary negligence may be allowed. With that said, thank you for your attendance today. If you have any questions or comments, please contact me. My email, jgrimske, Grimske, @seacrestwardle.com, or you can reach me via telephone number 248-851-9500. Thank you so much.